What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got, I guess this is part 3 now. Part 2 for this particular defendant. But this is the couple who decided to use poison to go after this guy's ex-girlfriend. Not even ex-girlfriends. People that went on a few this guy went on a few dates with. It's a bizarre story. This is arraignment number 2 for her. She, as the prosecutor said, new charges are coming. They came, and here's the arraignment. If you haven't seen the first 2 videos, I will link them in the description. I will put all this content together with some news articles to actually do a full story on it. I'm just getting the court content out right now, so we have something to refer to. Anyways, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, we'll call the case of State versus Andrea Whitaker. It's case 25-1426. Appearance of split judge.
William Brown, the state of Wisconsin.
That's yours.
Oh,
Thank you.
No one is. Yep. Right. And it looks like, Mr. Whitaker, you did get a copy of the complaint
I
there?
did, Your Honor. I can, Attorney Stan Wood is the defendant's office attorney on behalf of Ms. Whitaker, appears in person. She's eligible for a public defender. I do have a copy of the complaint in this matter, Your Honor, I just received. It appears in Ms. Whitaker's cases contained therein, looks like count 6. And count 4. And count 2. With regards to those counts, Your Honor, those are felony matters for the finding problem caused by the court. We'd be requesting a preliminary hearing.
All right, thank you. We did assign the co-defendant's version of the case to Judge Highland when he had his initial appearance earlier this afternoon. This case will be assigned to that same judge. I know that during that initial appearance, there was a victim present who wanted to speak and did speak. If that person's still present, they're welcome to talk at this time.
Yes, thank you. Can you hear me?
I can, and if I recall correctly, your initials were ML,
No.
or am I misremembering that?
No, Commissioner, we're just going to identify this victim as Dane County.
Okay, and now that I think about it, I think that was a set of initials for a completely unrelated case that we
Yes.
had.
It's late afternoon. Yes.
Yeah, it sure is. Yeah, that was a case involving something totally unrelated to this set of events. Yeah, so I'm sorry for that, but go ahead with your request regarding bail.
Thank you. On April 21st, I walked into my garage in broad daylight to see a complete stranger. I now know that that woman was Andrea Whitaker. I was terrified. She quickly left, walking down the road. My boyfriend and I got in the car and followed to confront her. She denied being in my garage and refused to explain why she was suspiciously huddled next to my vehicle. She circled my block, and when my boyfriend confronted her again, she responded with defiance, once again denying everything. Then came the moment that truly shook me. After police told me that my car break-ins were connected to Paul, I saw a picture of him with Andrea, the same woman I caught in my garage. That image still haunts me. It's been deeply unsettling, trying to understand how she was involved. For weeks, I've lived in confusion and fear. And now, in just the past few days, it's become horrifyingly clear. Andrea's intentions and actions, like Paul's, were to kill me. It is not at all clear why. Until I found her in my garage, I had never met Andrea. I went on 2 dates with Paul over a year ago. I told him I wasn't interested, and we were never in a relationship. I was never his girlfriend. And yet he and Andrea developed a delusion that I was. The fact that this delusion was so strong that they tried to murder me. Their actions and motivations are disconnected from reality. Both have shown their capacity for evil. How many other women have they plotted against? I do not know the answer to this, but what I do know is this. Andrea is not just unstable. She is dangerous. I will not feel safe if she is released. As this all unfolded, it was not clear to me what role Andrea played. But as I've learned more, it has become clear that she was an active participant in the plot to kill me. I cannot stress this enough. I have done nothing to this woman. If she can be so easily convinced to try and end my life, this court should have no confidence that she will not target some other member of the community to harm if she is released. We all have a right to feel safe in our homes, to walk our streets without fear. The only way I will be able to do this, and I believe the only way the community to know that she is not released to target others. Thank you.
Thank you. Mr. Brown?
Sure, the state's requesting cash bail be set in the amount of $10 million. As conditions, I asked that she have a GPS monitor fixed to rank before the release, that she have home confinements, that she provide an address, that she surrender her passport, provide an affidavit indicating she doesn't have one, that she have no contact with her co-defendant, and dime, that she have no contact with either victim labeled in the reports as Dane County victim and Rock County victim, that she be banned from the Midvale Heights neighborhood, which is defined as the area inside the streets of Mineral Point Road, South Whitney Way, South Midvale Boulevard, and the Beltline Highway. She be banned from North Spooner Street, West Skyline Drive, the 5600 block of Schrader Road, 2300 block of Crossroads Drive, and a ban from the entirety of Rock County unless she's in police custody or attending court in that jurisdiction. The victim probably said it best, but I will reiterate, I think the public is in danger, in extreme set of risk, either this defendant or Mr. Van Dyne were to be released. I said this on Wednesday when we had our first bail hearing. I think it would be easy in a case in which we see a man charged with such a serious crime, and we see a girlfriend or a love interest who's alleged to have helped him, charged with aiding a felon. It'd be easy to dismiss that as a case that we routinely see, because we do routinely see that case. It became extraordinarily clear in this case, however, that this defendant's involvement in the case was not as simple as helping Mr. Van Dyne hide evidence, which she did. So a court jail call. She was caught literally carrying a box and a computer, leaving one of his residences. It is likely that her involvement was perhaps just as significant as his, and she is just as culpable. Her phone has been searched as part of this investigation. Her research into the toxins at issue is significant. It appears that she thought up a good deal of this plan on how to do it. The issue with her being at the Dane County victim's house is extraordinarily concerning, given what happened in Rock County, in which one of the 3 ways that victim was poisoned was by the insertion of powder-based poisons in her air vents in her car. That is likely what was going on here. It is possible that there was some attempt to place tracking devices on these cars. That has not been determined yet, but there has to be some explanation for why Mr. Van Dyne somehow knew exactly where the victim was at various times when she was not at her residence, and that's still being investigated. I do believe Ms. Whitaker is just as culpable, just as responsible, just as dangerous as Mr. Van Dyne, who appeared in this court earlier today. I believe she presents an extraordinary risk to the public, even more remote than Mr. Van Dyne. Ms. Whitaker has no connection to Dane County victim. She has no connection to the Rock County victim, from what we can tell. This is simply her dating someone who might have a loose connection to these people, and she decided to help murder them. I think the risk to everyone involved, including witnesses, lawyers, jurors, eventually in the trial, is extraordinary. The only difference that I would say, and I have to concede, between this defendant and Mr. Van Dyne is that I don't know any resources in terms of other resources this defendant has. Although I will share that some of the jail calls that Mr. Van Dyne has placed since leaving custody, he has discussed whether family members would be willing to use their resources, which are significant, to bail this defendant out of jail.
Can I interrupt you for a second? If there's somebody back there that's volunteering, just their case put over to next week, we can certainly accommodate.
Just ask my part of the speaking.
Okay, thank you. Go ahead, Mr. Brown.
Sure, and the last point I was making is while it's nothing to do with this defendant necessarily, I should not let you know that Mr. Van Dyne has been placed jail calls indicating that he's asking or inquiring at least the family members of whether they'd be willing to post this defendant's bail. And as I indicated in his hearing, his family does have significant resources. I believe in this case, this is just an extraordinary set of facts that requires an extraordinary response, and that's what I'm saying.
Mr. Woodard.
All right, before we get into the defense, now, yeah, I'm not doubting those things were said by the boyfriend that, let's get my girlfriend out of jail too. She has a public defender. He has a retained attorney. If they were going to use resources to help her, I don't think she would have a public defender. I'm just going to say that to start. Also, strong statement by the victim. If you haven't seen the arraignment of the boyfriend, she said kind of the same things, but it was a little bit different. But yeah. Anyways, let's keep going. This is it's just blowing my mind.
Well, Your Honor, Ms. Whitaker doesn't have a lot of wherewithal to post in cash bail. The court did set cash bail on Monday for less than the amount that's being recommended by the state. At this point, until we have a preliminary hearing, determine what's going on with this case, I'm going to ask the court to maintain the cash bail that we have now. Till she gets appointed an attorney. I'm just her attorney for today's purposes. To get an attorney and find out more about her that maybe would help in regards to reducing bail, but I don't have enough information at this point to do more than what has been announced, but been ordered by the court on Monday.
I had an opportunity to conduct the initial appearance for Mr. Van Dyne earlier this afternoon. I was not the one who was present for the earlier bail hearing that Ms. Whitaker had on Wednesday. I have access to the outcome from that hearing, and of course, the lawyers at both of these hearings have made some description of what happened and what arguments were presented.
All right, real quick, I think this is important. Her first arraignment earlier last week, she was only charged at that time with harboring a felon. That's all she was charged with, harboring a felon, and she received a $750,000 bond. The prosecutor at that time said more charges are coming. These are those new charges. That's where we're at right now. So the defense attorney just said, the bond was less than what the state was asking. Like, yeah, they asked. I don't remember what they asked. I think they asked for $1 million for the harboring. Anyways, let's go.
As I noted when we had Mr. Van Dyne's initial appearance, I do have an obligation to set some sort of bail. It's not lawful under our statutes and constitution here in the state of Wisconsin for me to simply order that Ms. Whitaker be held without bail. That is not something that I think would be unreasonable to expect on the part of a victim. Many states would allow for that in a case of this sort. Wisconsin doesn't. So I have to set some form of bail or some eligibility for release. In doing so, I'm supposed to set it based on what's necessary under the totality of the circumstances to achieve certain goals. One of those goals is at least consideration. Well, the overarching goals are appearance in court and community safety. I'm supposed to consider factors like prior convictions for violent crimes, appearance risk, the need to protect members of the community from serious harm, the prevention of witness intimidation, and consideration of any affirmative defenses. I didn't hear anyone say that Ms. Whitaker has a prior criminal record or at least any prior history of violent crimes. Maybe both are true, that there's a lack of either. So I'm assuming that factor favors him. Appearance risk is pretty significant when somebody's charged in multiple counties with multiple counts of attempting to kill somebody, or in this case, multiple somebodies. The need to protect the community from serious harm is pretty obvious. I don't think it can really be overstated. The risk of witness intimidation is very substantial. And I don't see any real obvious affirmative defenses here. In some cases, I can look at what's alleged in the complaint and fairly reasonably assess relative culpability. It's always predictive. It's always sort of educated guesswork based on what's alleged in a complaint, but it can be fairly obvious. And sometimes that's an appropriate exercise because we try to weigh things. They're results that are supposed to be based on the individualized factors and the risks associated with that individual. I can't look at this complaint and figure out which person's alleged to be more dangerous. They're both alleged to be extremely dangerous. They're both alleged to have attempted on multiple occasions to kill multiple people by sophisticated means through advanced planning. I mean, the person who spoke via Zoom described this as a plot to kill her. It's, if what's alleged in the complaint is true, that's a fair description of it. But when I heard the word plot, what I immediately thought of is if somebody wrote this criminal complaint as the plot of a movie or a TV show, probably it wouldn't be taken seriously because it's so beyond belief or beyond. And I don't mean that to suggest that I think the state's allegation.
That's exactly what I said during the first video. This is real life villain. They're real life villains, is what they are. And you hear this stuff, when you're reading, like, oh, this military leader in this country used this biological warfare. Like, not just regular citizens. Put cyanide, powdered form of cyanide, in the air vents of someone's car. Allegedly.
Are not credible. There's extremely strong levels of proof if those facts can be borne out at a trial later on. What I mean is it's such an extremely unusual situation or set of occurrences that it does call for an extraordinary response. Mr. Brown's completely correct about that. He identified also what I see as a distinction between she and Mr. Van Dyne, who is said to have substantial resources available. Ms. Whitaker, there's less evidence of that. I did hear the comment about the possibility that there could be some sharing of resources involved in bailing her out. I don't think it's appropriate for me to set the same bail for Ms. Whitaker as I did for Mr. Van Dyne because I don't think there's this clear evidence of that that resource being present, but it's got to be substantial, and this is
Yeah, I disagree. The victim found her in her garage, actively trying to do something to her car. She's as culpable as he is. The prosecutor said it right. She is as culpable as him. It should be the exact same.
It's got to be a really high bail for, particularly even though it's a case where, fortunately, there were no deaths. I'm going to set cash bail at this case at $4 million. I will adopt the condition that she not be able to leave the jail if she posts that until she's outfitted with a GPS device. She'll be confined completely to her residence at all times if she gets out, except for going directly to and from court proceedings or previously scheduled meetings with legal counsel. She is not to be released until she's deposits with either the jail or the clerk of courts, her United States passport, or signs an affidavit attesting that there is not one, that one does not exist because it has not been issued. And I'll order the other various no contact conditions that were described by the state and the geographic restrictions. And of course, those will be monitored by GPS. She's entitled to a preliminary hearing in the next 10 days. Should we put that on right away, Mr. Wood?
Request, Your Honor.
Okay, we'll do that. We'll get it put on right away. That's an opportunity for bail to be reviewed also, Ms. Whitaker. That's certainly something that can happen. I hope things improve for you, and I certainly hope that for the person who appeared via Zoom as well. Good luck to you.
All right.
Thank you.
Right this way, Mr. Davis.
All right, that's it. I don't understand the signing an affidavit to say I don't have a passport. If someone is willing to attempt the act of unaliving somebody, I don't think they're gonna care too much about lying on a piece of paper. Can't they just look that up? I mean, I'm not whatever. I'm not going. They asked the guy had the same thing. The boyfriend had the same thing. Sign an affidavit saying you don't have a passport and turn it in. Yeah, they're looking at a lot of years, and the family has resources. They've said it in all 3 hearings. I wouldn't trust signing a piece of paper. I just wouldn't. All right, that's all I got. Like I said, I'm going to put all 3 of these together. I'm going to try to get these preliminary hearings. Like I said in the last video, this court generally just does its first appearances online. I'm going to see. I'm hoping that because of the I can't think of the word. You know what? I'm just going to stop. If words are hard, we're just going to end with that. You guys are awesome. Please hit the like button. I would appreciate it. Until next time, bye.
Next up is Felicia Williams. For bail bondsman.